Okay, so this is chapter 12, and we'll be talking about employment law. Now, the idea here is not to go on the specific rights and duties and obligations from employers and employees, even though we'll be talking a little bit about them. But the idea here is to give you a general understanding of what the employment relationship is, what the main obligations and duties are, and also talk about termination, because when an employee is terminated or when an employee decides to leave the company, there are some requirements. When the employee is terminated, the employee may have some rights. So it's important to talk about termination. And then we'll also be discussing issues related to human rights, health and safety, workers' compensation, employment insurance. Now, the last part of this chapter is related to unionized workers, collective bargaining. So that part I will not cover. My colleagues and I, we don't cover collective bargaining in this B law course. That is dealt with by the labor relations instructors. So you will see in the last part of the slides that the slides have a different color. Those parts are not applicable. I kept them there because the publisher gives them to us. And if you want to read, if you want to know more, you also have the textbook. You're also welcome to ask me questions after you read and review them. But that part I will not cover in the lecture, nor is that part applicable for the final exam. So that collective part, collective bargaining in the end will not be examinable. Okay, so keep that in mind. Now, we're going to start employment by learning what employment relationship is. When is it employment? When is it providing of a service? Would you agree with me that if a gardener comes to my house for the gardener is not my employee, even though the gardener is someone doing work for me? So it's important, first of all, to differentiate when a worker is an employee, when a worker is an independent contractor, a self-employed person, individual. So employment involves one person, a worker, doing work for another. But this another is known as the employer, and they are also known as the master because they direct, they supervise the worker, the employee. So an employee is in this master servant relationship, and here there's nothing about uh, master being more important or not. Eventually in the future those terms will be changed because of human rights, but for now we understand them as the master is the employer giving direction, supervising, and the servant being the employee working under those directions, complying with their job duties under the direction of the employer. Now, an independent contractor can also be known as a freelancer, but freelancer is just a, um, how can I say, it's just an expression, but it's not commonly used legally speaking. In the legal environment, freelancers are referred to as independent contractors. So the example I gave you about a gardener coming to my home, when you hire a lawyer for a specific case, so they are independent contractors. They are not your employees. And companies, they also hire people to do work for them, but as a service, as a specific service, not in an employment relationship. Now, sometimes, unfortunately, companies hire employees as independent contractors. In other words, they should be hiring an employee for the specific job because they will be directing, supervising, but they don't want to hire as an employee. They want the worker to be an independent contractor. Now, why? Why does this happen? Why do companies or why do some companies hire workers as independent contractors, even though they have a work shift, a work schedule, they are supervised, they are directed, they are given the resources, etc. Why? Why do some companies do that? Why do you think? Taxes? That's right. That's one reason. Exactly. Companies, they have to pay taxes for employees. They have to remit their part. They have to withhold. They have, yeah, taxes in general. Now, with regards to independent contractors, no, they don't have, or they don't have as many taxes as they would have with an employee. That's right. So it's on a financial aspect. They want to save money. That's right. There are other reasons. What are other reasons? Is an employer vicariously liable for the wrongful conduct of an employee? Yes, Joyce is saying EI. That's right. EI, employment insurance. So employment insurance is owed to is applicable to an employee, not applicable to an independent contractor. That's right. So yes, Diego is saying yes. Employers, they are vicariously liable for the wrongful conduct of their employees. In principle, they are not vicariously liable for the wrongful conduct of independent contractors. So there's some liability there. They are trying to avoid liability. There's also the aspect of workers' compensation. Now, they don't have to pay the premium for workers' compensation, and it's also bad for the worker because the worker is not covered under workers' compensation. Now, even the worker, which should be who should be an employee, because they are independent contractors, they are not paying taxes in their side. So taxes are not being deducted in their side as employee. So the worker may also suffer penalties from CRA. Now, you understand that the main point here is legal liability or liability and financial aspects. So companies would take the risk to have a worker who should be an employee as an independent contractor, mainly because of liability and financial matters. Now, let me tell you that courts and governmental agencies, they will apply some tests whenever they are in about the real classification of a worker. So usually when a worker is there as an independent contractor, courts will apply, governmental agencies will apply those tests to assess whether that worker is a real independent contractor or is actually an employee. The main test is this control test. So the control test is related to this master-servant relationship because the employer is directing, is supervising, is controlling what the employee does. So the employee serves the employer. I serve BCAT. So BCAT controls what I do, what courses I deliver, schedule, assignments, marks, etc. So BCAT has control over what I do. Now, the gardener, when the gardener comes to my home, they have control over their job. If they want to start from the front yard or from the backyard, if they want to start mowing the grass or trimming the trees, well, they control. All I did as a client, I hired a service and they have to deliver a service. So you see the difference. Now, if a company hires a worker but sets the work schedule for the worker, this is controlling, sets what they have to do, directs them, supervise them. So it's more on a control aspect than an independent contractor. Does it make sense to you? Can you understand this control test? The employee is actually working for the employer, whereas an independent contractor is providing a specific service to the employer, but it's not under the direction, under the control, under the supervision. Does it make sense? Can you give me thumbs up or just say yes or no? Yeah. Now, there are other tests, such as the organization test, the risk test, the tools test. So organization test. Am I part of BCAT? Well, when you register for this course, my name was there. I have a BCAT email. I have an office. So according to the organization test, I am clearly an employee. Now, a gardener that comes to my house, an accountant that I hired for my income tax filing, or even as a company, I have an accountant, but not as an employee. I have an accountant who has their own firm, but because I'm a small business, I hire them for specific matters. So they are not part of the organization. Again, what are the factors that tell that the worker are part of the organization or not? So I've just given you my example. Now, risk test. Risk. Who bears the risk? Who runs the financial loss? Who runs the risks for this course? It is BCAT, not myself. If this course has only 5 students and BCAT will run on loss, it's their risk. If they run on profit, it's their profit. Because I will have my wage or my salary or my amount paid no matter what. So again, on the risk test, if the risk will be borne by the employer, then it's an employment relationship. Now, when the gardener comes to my house, if there's a flying rock that breaks my window or the neighbor's window, it is the gardener's responsibility because they were providing the service. If they come here and their machinery is broken, their risk. If I don't pay them, their risk. They have to sue me. So you see that in an employment relationship, the risk is with the employer. Whereas in an independent contractor relationship, the independent contractor will bear the risk. Okay? And the tools test. Well, BCAT has given me this laptop. I have an office. Again, I'm provided the learning hub, the learning management system, teaching tools, etc. So again, it's an employment relationship between BCAT and myself. Now, the gardener, the accountant, a business consultant, if they work on their own, they will have their own laptop. They will have their own subscriptions if they need to. They will have their own tools to work with, right? So those are the main tests: control test, organization test, risk test, and tools test. And there are more. There are more tests if you want to. If you just Google, let me show you. And if you are interested in learning more about this, you can just Google employee versus contractor CRA. So CRA has a very nice content related to this. It's not legal advice, nor is the lecture here, but it's a very good guide. So if you are an employer or a worker, yeah, you can go deeper into this. So if you are interested, or if this becomes relevant to you, either as a business person or as a worker employee, this is a good source for you. So those are the tests. And why are those tests again there? They are there because if courts or governmental agencies, if they believe the company has a worker as an independent contractor, but that worker should be classified as an employee, then they will apply those tests to learn, to get to the result whether that work is an employee or not. Okay, so that's why those tests are used. Question for you. Okay, which one is right? Which one more accurately describe an employee? Okay, A. So the person is an essential part of the employer's organization. Yeah, makes sense. A is the right one. And even if you are in doubt about A, well, look at B. They have their own tools. If they have their own tools, they are more an independent contractor than an employee. C, they are free to represent others in the same business. More independent contractors. So gardeners, they can represent several clients, lawyers, accountants. Now, as an instructor, as an employee of BCAT, I cannot represent others while I'm doing my job. D, the person determined their own work schedule. Lack of supervision here, lack of direction, more of an independent contractor than an employee. And the person has a high level of financial risk. Again, risk test. If the financial risk is on the person, on the worker, they are more of an independent contractor rather than an employee. All right, so A is the right answer. Very good. So let's continue now. Well, some obligations. So now we differentiated an employee from an independent contractor. So from now on, we'll be talking about employment relationship. Okay. So in an employment relationship, the employer has the obligation to pay wages, salary, whatever was negotiated, the benefits, etc., and to provide safe working conditions. So as an employee, we have a right to a safe working environment. If I get to BCAT and the classroom is not safe, there's, I don't know, some electrical sparks or some leaking in the roof, something, I have a right. I have a duty, but I also have a right not to provide my services there, not to work there. It doesn't mean I should go home. No, I should report to my supervisor, in my case, my associate dean or the program coordinator, and then they will probably get me to another classroom. Okay, so those are the main obligations of the employer. And they also have to comply with the agreement. Now, the employee has to be competent, and this is a subjective test. They have to be honest, loyal, punctual. They have to act in the best interest of the employer. And depending on their job duties, they also have fiduciary obligation. Remember, fiduciary obligation is that enhanced duty, acting only in the best interest of the employer. Now, remember, in this course, I have the rule tardiness. If you are more than 15 minutes late, you don't get attendance. You're welcome to attend the lecture, but you don't get attendance. Well, this is because in the workplace, this works the same way, because we have a duty to be punctual. We have a duty to be honest, to be loyal, to be competent. Okay? And those duties, they don't need to be in a contract. They are implied duties. It is expected from employees, because they are getting wages or salary and benefits, that they will be competent, they will be honest, loyal, punctual, etc. Now, employment relationships, they are based on a contract. So there's the employment contract. You are already knowledgeable about contract law. This is to say that you know that all ingredients necessary for a valid contract, they have to be there. An employment contract needs to have consensus, in other words, valid offer, effective acceptance, needs to have consideration, needs to have, parties need to be capable, and usually they are, needs to have a legal subject matter, and usually the employment is, unless if we were talking about sexual services, immoral conduct, and there has to be intention, and usually there is. So all the 5 required elements have to be there in a contract of employment. Now, let me tell you this. The main law for employment relationship is the contract. Attention to what I'm saying. I didn't say the only law. I said the main. The main law is the employment contract. Now, as long as the contract or the clauses, the provisions, they are legal, they are compliant with the law, with the legislation, the employment contract is the main source of law in your employment relationship. Now, why am I saying this? I'm saying this because whenever you have a doubt about your rights, about your duties, or if a friend comes to you and says, hey, I know you are taking this B-Law course. So I have an issue in my job. Can you help me with some alternative or with some suggestions? Well, first of all, you have to say, sorry, I'm not a lawyer, so I cannot give legal advice. Then you can say, well, this is not legal advice, but from what I learned, first thing you have to do is look at your employment contract. First thing you have to do. Then after that, you can then look at the legislation, you can look at the law, you can start looking at other things. So the employment main source of law in an employment relationship. Now, there may be restrictive covenants in an employment agreement. What are they? They are confidentiality, they are non-competition, they are non-solicitation. We saw them already, but we saw them in a perspective of business relationship. My example to you was, I would buy your pet shop and I would want you to not compete with me for at least 1 year. I wanted you not to solicit on your former employees, suppliers, clients, etc. So we learned that restrictive covenants, they are possible as long as they are reasonable in the geographic limitation and time limitation. Now, when we talk about employment agreements, we are talking about the right of people of making their own living. I'm saying this because those restrictions here, the reasonability of geographic limitation and time limitation, they are even more strict. In other words, 2 years may not work, may be too much. Entire BC, you cannot do anything, you cannot work for a competitor in entire BC, may not work. Because people, workers, they may have a right to make a living. So the message is restrictive covenants in employment agreements, they have to have very highly reasonable limitation in terms of area and time. And by the way, in Ontario, for example, it's been over a year now that non-competition is prohibited. Non-competition cannot be used anymore because the Ontario politicians, the Ontario government understood and changed the law, understanding that non-competition is not good. It's not good for employees. So they made it a prohibition. This is not the case in BC yet, but courts don't like very much the non-competition in employment agreements. Now, if you have a restrictive covenant in your employment contract, if they are not reasonable, they are illegal. They are void. Not the contract, just the part, just the restrictive covenant. They are illegal. Now, if you get a job offer, you accept the job offer, and then you get the employment agreement to sign. And then you read before signing, you read the agreement. And let's say the restrictive covenant says that you cannot work for a competitor anywhere in Canada for 1 year. What would you do? Okay, I'll repeat. You get a contract of employment to sign, so you start for that company. And among other provisions, one provision is on restrictive covenants saying that by agreeing to that contract, when you leave the company, you agree that you will not work for any competitor anywhere in Canada for up to 1 year. What would you do? Would you sign? Would you do anything else? Would you not? So what would you do? And why? You would negotiate. Okay. Yeah, it's possible. So you would tell them that you would explain to them that it doesn't seem reasonable. Okay. Yeah, it's possible. You could sign, but it might be hard to get a job in a similar field if you can go to a competitor. If you can't go to a competitor. Yeah, that's right. It would be hard. You sign it, the term is illegal, even though I signed. Ah, I'm not giving you legal advice. I can't. But I like Joyce's approach because the company drafted the agreement. They have the burden to prove that the restrictive covenant is legal, is enforceable. So I would do the same. I would sign, knowing that because it restricts me from competing anywhere in Canada, so it's legal, it's not reasonable. And yeah, I would just work. Then I would, when I leave the company, if I had an opportunity to go to a competitor, I would go. And then if I were sued by my former employer, I would plea in my defense that the restrictive covenant is unreasonable and should be void, not enforceable. See, so again, it's not legal advice, and you could negotiate, you could not sign, but by understanding that the employer has the burden of proof, they have the duty to draft this restrictive covenant in a reasonable way, in a legal way. I would say that the best approach is this: sign, accept, eventually seek lawyers' legal advice, but eventually sign, work. When you leave, it's not that you intend to go to a competitor, but if you leave and then you have an opportunity in a competitor, you could go and you could still raise a defense in your favor. Okay, so that's how I would approach. And again, this is not legal advice. I'm not here giving legal advice. That's a good one. Now, okay, before we talk about termination, so Diego has a question and a comment here. Let's say the employee left the company and after 3 months, the employee found an opportunity in the same field. Since they are not allowed within the next year, can this person engage with a different company as a contractor? Does that make a difference? Well, if the restrictive covenant is reasonable, both in time and geographic limitation, then what you are suggesting, working as a contractor, could be fraud, because you, if I understand correctly your question, you would be using a different type of relationship just to get away from the provide services to a competitor. So I don't think it would make a difference if the former employee were able to collect proper and credible evidence on that. I think they would have a better chance of winning, because at the end of the day, what really matters is the fact. What is the fact? The fact is that you are working for a competitor, even though you're a contractor, not an employee. So I would be more on the side of the former employee in this example. All right. So now talking about termination. Well, we just talked about employment contract, and now we're talking about terminating. Yes, because termination is an important aspect in the employment relationship. Why? Because first of all, an employer, they can dismiss any employees at any time for any reasons, except for illegal reasons, except for reasons that violate human rights. In other words, the employer may dismiss the employee because they don't want the employee anymore. The employee is not performing as they wanted, even though they are not performing badly, but not as they wanted, or because the business is not going well, or because they are thinking about a different strategy, etc. Anything. But they cannot dismiss because I am from Brazil, or because of my color, because of the color of my eyes, hair, because of my ethnic origin, my gender, my disabilities, and could be physical or mental disability, religion. So all those protected grounds in human rights legislation cannot be used to dismiss an employee. Now, yes, in real life, sometimes employers, they rely on those protected human grounds, in protected human rights grounds, but they don't tell you. They just don't disclose the real reason. Well, as I just told Diego, at the end of the day, if you are able to prove that you were actually dismissed because of one of the protected human rights grounds, you would file a complaint. Okay, you would have grounds. You would be entitled to file a complaint. Now, so that's the basis. Employers can dismiss employees at any time, but they have to follow some requirements. What are those requirements? Well, there are three ways. First, they would dismiss an employee by giving a reasonable working notice. Giving a reasonable working notice means the employer comes to me today and say, hey, João, you are being dismissed, and your will be 1 week, 2 weeks, 1 month, 2 months from now. So that's the reasonable working notice. I am under notice, but I'm still working, and I know what my last day is. So I have a right to this if I have worked for a company more than 3 months. More than 3 months, I am entitled to at least 1 week reasonable notice according to the law. That's the minimum. Okay? Now, if the company wants to dismiss me, but they don't want me to be working after the notice because, I don't know, they believe I may treat clients in a bad way, or I may perform my job duties in a poor way, or etc. Or they just don't want me anymore there. So instead of giving me a notice, they can pay me the equivalent of the notice. So if I have worked for a company for 5 years, I would be entitled to 6 weeks, 6-week notice. And then the company would come to me and say, hey, João, you're being dismissed. You can just pack and go. And in 5 working days, you can come back, or we will make you a deposit of this amount. So the amount is equivalent to the notice. Now, the company has the discretion, the employer has the discretion to decide whether they want to give me a working notice or they want to pay me in lieu of the notice. And they can do both. Let's say I'm entitled to a 6-week notice, and they say, hey, you're going to be under working notice for 4 weeks, but then the last 2-week period, you will be compensated. You will be paid in lieu of the notice. So they can decide. Now, while I'm in notice or with the payment in lieu of notice, I'm entitled to my wages or salary. I'm also entitled to my benefits, commission, bonus if I have any, etc. Everything as if I were working normally. So those are the two most common ways. Either, and this is when the employee is terminated without just cause. There's no just cause. It's just being terminated because the employer doesn't want them anymore. So they are entitled to either a working notice or payment in lieu of the notice. Now, another way the employee may be dismissed is when the employee acts wrongfully. So if the employee acts wrongfully, let's say the employee is involved in a sexual harassment, is involved in another criminal offense, stealing, theft, etc. We'll see other grounds in a minute. Then the employee any notice. The employer will come to the employee and say, hey, you are being dismissed with just cause. With cause. You gave cause. So pack up and go. You are entitled to any amounts owed to you until this day, not anything after, because you gave cause. Now, most of the litigation against former employers is related to employees who were dismissed with just cause, but they sue because they believe the just cause is not valid. The just cause is not correct. So they want the court to change that reason and then allow them the compensation, the amount they would be entitled. So that would be a wrongful dismissal lawsuit. Could also be that I am entitled to 6 weeks and my employer just gave me 4. This is also wrongful dismissal. So I can sue my employer for the amount I haven't received. Now, what is this common, what is this reasonable notice? So I just told you, it's roughly, it's not a specific formula, but it's what is in the law, 1 week per year of service. So year 1, 1 week, year 2, 2 weeks, and then goes on. Now, that's the minimum. If you want to know how many weeks or how much time, how long you are entitled as a working notice or payment in lieu of notice, where do you look at first? Where would you go first? Anyone? Where do we know the specific amount of time we are entitled to? Contract. Thanks, Leticia. Yes. The first place to look at, remember what I told you some minutes ago, the main source of law, not the only, but the main source of law is the contract. Because the law sets the minimum amount. But what if the employer in the employment agreement has set a longer time? So you are entitled to that longer time. Now, if the employer has set a time that is less than the minimum, then that time is not applicable. Because again, the employment contract has to be at minimum equivalent to the law. Can be higher, can be greater, but not less, because this is a right to the employee. Okay, so if your employment agreement says 1 month, it's 1 month. If it's 1 month means 4 weeks. If you have been working there for at least fewer than 4 years, you are entitled to 4 weeks, 1 month. You've been working there for 180 days, less than a year, more than 90 days, but less than a year. And the contract says 1 month. They have to comply with the contract, 1 month. Okay, so the first place to look at is the contract. Then you can compare with the law. If it's the same as the law or greater, it's fine. Follow the contract. If it's less than the law, forget about the contract. Forget about the law, because the courts, they have their own way of assessing time. So whenever someone sues for wrongful dismissal, the courts will apply other factors for the time. And they are known as the Bardau factors because of the Bardau case law from the Supreme Court. So courts, they will look at the length of service, type of job, age of the employee, etc. And here the rule of thumb is that courts usually apply 1 month per year of service. So now let me give you this example. I've been working for 5 years. So I've worked for 5 years and now I'm being terminated. And I'm being terminated and I'm being given less than the 5 weeks I'm entitled to, or I'm being terminated for just cause. But I believe that just cause is illegal, is not applicable in my case. So I would sue for wrongful dismissal. If I win, most likely I would be entitled to 1 month per year of service. So about 5 months of salary, benefits, everything as compensation. Now, the key lesson is here. The key lesson is that if employers do not follow the law, at least courts will award much more. Will award 2, 3 more than the law said. So you see how risky it is for employers to be sued for wrongful dismissal, because their liability may be great. Now, what about probation period? Yes, good question. That's why I said after 90 days, if you work more than 90 days, because probation, according to the law, is up to 90 days. If you work 91 days, then you are entitled to the reasonable notice or payment in lieu of the notice. But up to 90 days, you may be on probation. Then no notice is required in principle, but there may be exceptions there. Okay, so probation is 90 days. Does it make sense? So that's why termination is so important. That's why we're discussing termination here, because the minimum is applicable, or if the contract provides for greater time, that greater time will be applicable. But in a wrongful dismissal lawsuit, courts, they have their own parameters, their own factors. They don't follow the law. So you see how risky it may be for employers. All right, so just cause. What is just cause? Well, just cause is when the employee gives cause. When the employee is guilty of any wrongdoing, or when the employee fails to perform the job. And examples could be absenteeism, tardiness, being late, disobedience, insubordination, incompetence, harassing others, drunkenness, immoral conduct, criminal offenses. So those are all reasons that may lead to dismissal with cause, just cause. However, let me tell you this. Courts, they are more protective of employees than employers. So now what courts have developed is this guidance. Unless the just cause, the wrongdoing, unless the wrongdoing is very serious, such as a criminal offense, sexual harassment, a theft, or physical violence, unless it's that serious, courts require employers to develop a progressive disciplining process. In other words, if I am late, I should receive a warning. And I should receive a first warning, a second warning, eventually a third and final warning. So there has to be this step-by-step progressive, which is a progressive disciplining process. The employee needs to know that their job is at jeopardy because of their wrongdoing, because of their poor performance or failure to perform the job as they should. Okay, so some employers don't know about that, and then the employee misses one day, and the next day they are fired for just cause. Most likely, and courts will also look at the history of the employee. If the employee had been working for 1, 2, 3, several years, and it was the first time they missed the job, most likely, if they are dismissed for just cause and they sue for wrongful dismissal, they may win. Okay, so the key aspect here, the key lesson here is courts require progressive disciplining, a step-by-step disciplining process, unless the wrongdoing is really serious, is very serious. For example, a driver showed to work to drive intoxicated. Well, intoxication may may trigger the duty to accommodate. But what I mean here is driving a company car under the influence of alcohol or the influence of illegal substances, drugs, may be a serious issue, may be serious in a way to constitute just cause. It's more serious if, let's say, if it's a school bus driver, for example, and not only showing to work, but if the driver was caught after driving the kids, for example. So depends on the situation, but again, the more serious it is, the more successful employers may be in a just cause. If not that serious, they have to discipline, they have to give a warning. And usually, it's just an example, it doesn't need to be like this, but usually it's a verbal warning first, and then there's a written warning, and then there's a final written warning as a third one. So it's just an example here. Now, if there's just cause, no notice is required. No payment in lieu of notice is required. So you are dismissed right away. Okay, that is the consequence for just cause. All right, let's break. Let's break for 10 minutes, and then we'll be back. Let me pause. Okay, so when we talk about illness and disability in an employment relationship, illness and disability, as we discussed in Chapter 9 in contract law, may lead the employment contract to be frustrated. In other words, it could be an outside, unforeseen situation, performance of the job duties impossible, or it could be that the business doesn't exist anymore. Again, outside, unforeseen event. Now, if it's not frustration, then the employer has the duty to accommodate the needs of the employee to the extent that it does not cause an undue hardship to the employer. So if it is the case that I cannot be standing because I have some, let's say, I don't know, back pain or some issues in my legs, could be temporary, could be permanent, then BCIT would have to accommodate. If it causes them an undue hardship, then they wouldn't they wouldn't need to accommodate. This accommodation is a shared responsibility between the employer and the employee. So they need to discuss, they need to agree together. And remember, the employee may always be dismissed without cause, as long as the employee is paid the reasonable notice or is given a working notice. But the accommodation is there, and the accommodation is an obligation. Again, unless it causes an undue hardship for the employer. Okay. Now, layoff. Well, first of all, if the employer runs out of work, let's say a ski resort or an ice cream shop, if they have no business, this is not a reason, a just cause to dismiss employee. No. If this is the case, or if they have financial problems, they still have to provide the working notice or payment in lieu of the notice. Okay. Now, temporary layoff may be possible. May be possible, and I say may be possible because, well, first of all, it has to be in the agreement that layoff is possible, or it has to be an industry practice for that specific industry. So if either one is the case, then a temporary layoff is possible. A temporary layoff is when the employer tells you that you are temporarily being laid off, but there's a limit for 13 weeks, up to 13 weeks. If it's 14 weeks and you were not called back, it means you were wrongfully dismissed because you were entitled to the reasonable notice and you were not given. You were actually dismissed, wrongfully dismissed through temporary layoff. So again, temporary layoff is possible if it's prescribed in employment agreement or if it's a common practice in that specific industry. but there's a limit up to 13 weeks. After 13 weeks, you have to be called back to work. And then if you're called back and there's no job, that the employer is still bad, financially speaking, well, they can now dismiss you without cause by providing you the the payment in lieu of notice, because you won't be able to be working at that time. So that's how it works. Now, this concept of constructive dismissal, what is this? What is constructive dismissal? Well, it is when the nature of the job changes without the employee's consent, or the working conditions become intolerable. Let me talk about the second factor first. So sometimes the employer wants the employee to leave the company, and they don't want to dismiss the employee. So they want the employee to leave. What happens is that in some of those circumstances, the employer, they just allow the working condition to be intolerable, to be bad. So let's say the employee is suffering from bullying, harassment, bad management, etc., and the employer doesn't do anything to address those things. If this is the case, this is an example of constructive dismissal. Another example or another circumstance for constructive dismissal is when the nature of the job is changed. Well, a simple example is this. I was hired for 40 hours per week. The employer comes to me and says, hey, starting next Monday, you will be working only 20 hours per week. It's changing the nature of my job half the time. And I didn't get the employer didn't get my consent. They just changed. Or if I am a lecturer and then I changed, my job changed to an administrative job at BCAT, for example. So those are examples in which the nature of the job is changed without the employee's consent. That's constructive dismissal. Now, constructive dismissal leads to a breach of contract. It means that the employer is breaching the contract. What is the consequence? Well, the employee, the victim of the breach, they can leave the job and they can sue for wrongful dismissal, because they will sue for the amount they would be entitled if they were correctly dismissed without cause. Now, remember that when there's a breach of contract, the victim has a duty to mitigate their loss. So the employee, if they leave because of constructive dismissal, they would have a duty to update their resume, to try to apply for other jobs if opportunities show up, etc. Oh, that's the duty to mitigate we also learned before. Now, this is not legal advice, but if you ever believe you are in a constructive dismissal situation, my thought, it's not advice, but my thought is seek legal advice before leaving the work. And why do I say this? Because it may be that you leave because you believed you were in a wrongful dismissal, then you sue for wrongful dismissal, then the court understands differently. The court understands that what you believed to be constructive dismissal was not. And then you end up losing your job and also having to pay legal fees and etc. So if you are ever in such a situation before taking any action, but then you know what constructive dismissal is, so that's why you would be able to seek legal advice before taking any action. Now, when you are a victim of wrongful dismissal, what are the available remedies? Well, you sue and you would get the compensation you were entitled had you not been wrongfully dismissed. But now remember, if you sue for wrongful dismissal, courts, they will apply those factors: the length of your service, type of your job, your age, your qualifications, availability of similar job. So as I told you before, the rule of thumb here is 1 month per year of service. Okay, so that's what you get, or you would get, as compensation when you sue for wrongful dismissal. Now, wrongful leaving. Can you leave? Can you resign without reasonable notice? What do you think? How do we know if an employee needs to give a reasonable resignation notice or not? How do you know? Do not overthink. The answer is on the screen. The question is, how do we know if we have, as an employee, if we have to give a resignation notice or not? Depends. Yeah, that's the lawyer's answer. Yeah, lawyers will usually say it depends. But it depends on what? So how do we know? No. I mean, you want to leave the company. You don't want to work anymore. I don't want to work for BCAT anymore. I don't know. I'm moving countries, or I'm going to another company. I just want to leave. I want to resign. I want to move on to another opportunity. How do I know if I need to give a notice? Yes, Leticia, that's right. Look at the contract. Does your employment contract require a notice, a resignation notice, a leaving notice? If it requires, you have to follow that notice. Now, the law does not require a resignation notice. You can just leave. But courts do. Courts require a similar notice as the reasonable termination notice. Okay? But again, remember what I said in the very beginning. First place to look at is the contract of employment. If the contract of employment, if the employment agreement says, if you want to leave, you have to give a 30-day notice, you have to give a 2-week notice, then you have to comply with that notice because it's a term of the agreement. Okay? So that's what wrongful leaving would be. Now, employees can also be sued if they breach confidence. Breaching confidence is disclosing confidential information. If they breach a restrictive covenant, non-competition, non-solicitation, if they breach fiduciary duty, depending on their positions, their job duties. So those are grounds in which the employer could sue the employee. You can leave without notice, but you pay for damages instead. What do you mean? So you leave without notice, you will pay for damages only if you are sued for, right? Now, let's say my daughter, she got a job at Starbucks. If she wants to leave just tomorrow, well, she has to look at her employment contract and then follow that notice. If she doesn't follow, if she just leaves, she just calls the manager and says, hey, I'm not coming anymore. It could be that Starbucks could sue her for the wrongful leaving. And then there could be damages. Is this what you mean? Is it too? Yep. Okay. All right. So the point here is that the employer, they may have reasons, they may have grounds to sue a former employee. So it's not because courts are more protective of employees than employers that employers never have reasons to sue former employees. No, they may have. And these are some of the reasons. If they leave wrongfully the job, if they breach agreement, if they breach confidence, fiduciary duty, etc. Now, liability of employer. Well, this you already know. Employers are vicariously liable for the wrongful conduct of their employees. Now, I have underlined here The conduct of the employee has to be related to their job duties, has to be connected to work, right? It's not anything. Let's say, because I'm Brazilian, I like soccer. Well, I don't mean all Brazilians like soccer, but I do, or most Brazilians do. And because of this, I start a soccer argument with a student, and then we have physical altercation. Well, that was not related to my duty of being a lecturer, etc. So this is just to differentiate here. Two questions. First is, João, is the hourly employment less complicated, legally speaking, than a contract employment? Interesting question. There's a contract of employment in both situations. The fact that you get paid by hour or that you get paid as a salary, there's still an employment agreement. By contract employment, I would understand a temporary contract, not a permanent one. But again, the fact that I get paid by hour, or there's still a contract of employment, and all duties, all obligations, or all responsibilities are there. So that's what I can say if I understood your question correctly. Joyce, if the employer didn't sue, is there some result for leave without notice? Well, there may be if your potential next employer gets a reference check, if they call your former employer just to learn about you, and your former employer says that you left without notice, which is not a lie, is a fact, that may be negative for you. But I don't see anything else other than this. Yeah, if they don't sue, no further consequences, I would say. All right, so that's vicarious liability, and we know that the employer can go after the employee later on, but it's common practice that they don't do this. They rely on their liability insurance, so on and so forth. But they could if they wanted. Employers are responsible for the misuse of computers by employees. Well, this is the same as vicarious liability. If an employee misuses a computer, they are acting wrongfully. And if they are acting wrongfully in the course of employment, employers are vicariously liable. So it's the same thing, but with a different perspective. Employers can monitor the employees' activities online as long as they forewarn, they tell the employee in advance that their activities will be monitored. So employers usually do this through their policies. When we start a new job, we usually sign an agreement and we are given copy of several policies, and usually there will be an online activity policy or a policy. There could be something related to harassment, work safety, etc. So the employers, they can monitor as long as they told the employees in advance that they would be monitored. If not, they may commit the invasion of privacy tort. Now, my question to you is, the laptop I'm using is from BCAT, and what if I log on to, and BCAT has told me that through their policies that they monitor my activities online. Now, what if I log on to my personal email? Can they monitor that or not? Yes or no? No. Diego says no. They cannot monitor. It may be surprising, but the answer is yes, they can. Because they're monitoring their device. The fact that I have logged on my personal email was my choice. I know my activities using this laptop may be monitored, and I decide to log on to my personal email using this device. So we got to be cautious on that. If you want to keep your privacy on your personal matters and issues, make sure you do not mix your affairs while in the company's internet, Wi-Fi, while in the company's owned laptop, smartphone, etc. Okay, so that's a bit tricky, but that's how it is. Question for you. Right answer. Anyone? B? E? E? Why are you saying E? Why E and not the others? What is key about E that is not present in the other ones? Exactly. Because E is the only one in which Jones seems to be an employee. The other options are seems that Jones is an independent contractor. And with independent contractors, in principle, there's no vicarious liability because they are just a service provider. They are not under the direction. They are not under the supervision of the employer. So you are right. E is the right answer. If Jones is a secretary working in Smith's office, then Smith is vicariously liable for Jones' tortious, wrongful conduct. Any questions? Any doubts? Does it make sense? All right. So, and it's not B. So B says John is a computer programmer working for ACE and is installing new software for Smith's department store. So if Jones acts wrongfully while installing the new software, who is vicariously liable here? Is it Smith's or ACE's? ACE computer. Yes, that's ACE because Jones in B works for ACE. Jones in B is not an independent contractor, is an employee, but is an employee working for ACE and then providing, performing their job duties in Smith's location, but they don't work for Smith. Okay, that's right. Very good. So E is the right answer. Jones is a secretary. Very good. So now we're going to talk a little bit about some legislations or some laws that are applicable for employment relationships. And we'll start with the main one, the Employment Standards Act. Well, let me tell you this. Most employees in Canada, about 90% of them, they are provincially regulated. In other words, there's provincial employment legislation, and the name is Employment Standards Act that is applicable to them. And why do I say 90%? Because there are about 10% of employees that are federally regulated. They are regulated by the Canada Labor Code. How do we know this? Well, industries that are of importance to the federal government, such as post office, airlines or air transportation, interprovincial transportation, banking, security. So those more important industries, employees and employers, they have to be federally regulated. But everyone else, they will be provincially regulated. So that's why 90% of people, employees in Canada, they are provincially regulated. And when I say they are provincially regulated, I mean provincial law, provincial legislation is applicable to them. So as I said, we have the Employment Standards Act. And this act, the Employment Standards Act, is the main law for employment relationships. Not the only law, but the main one. So this law will set the minimum standards, the minimum rights. Now, the employer, they may offer more than the minimum, but not less. So the employer may offer more than a minimum wage, but not less. The employer may offer more rest period, but not less. Fewer or more hours of work, or they have to pay overtime. So the basic rights, the minimum standards, they are in this legislation. Okay. Minimum vacation, 2 weeks per year. Employers may offer more, depending on the industry, or if they find it difficult to hire good employees, they may offer 3 weeks, 4 weeks, well, but not less. Okay, so that's how the minimum standard works. Now, I'm going to give you 10 minutes. I'm going to have you in breakout rooms, and I want you to find the answer for this. What is the minimum wage here in BC? What's the maximum number of hours you can work on a daily basis, weekly basis, rest period? How's overtime dealt with, vacation, holiday? Is paid sick leave a right? So I'll give you 10 minutes, and then we'll be back here to talk about them. We are 18, okay. Assign automatically, next. No. Cancel. Just need to set the time, I think. How do I set the time? Okay. Open rooms. Okay. Go to your breakout rooms and work on this. Let me resume recording here. Yeah. So this is a nice resource. You have all the PC. It's usually updated every June 1st. So it was just updated last June 1st. It moved from 1675 to 1740. Now, as we're discussing here, there's no specific minimum wage for liquor servers anymore. There used to be until 2021, but 2020, and then after 2021, no, it's the same minimum wage for everyone. Now, hours of work, I saw you, some of you discussing, that's right. There's no limit of hours, but there's a subjective limit in terms of safety. But if you work more than 8 hours in a day, you are entitled to overtime, 1.5, your average hour. And if you work more than 12 hours, any hours exceeding 12, you will get twice, 2 times your average hourly wage. Rest period, 32 hours from one weekly shift to the other, and 8 hours from one day to the other. But again, if you don't have that rest period, it means you are entitled to overtime. The weekly hours of work, 40 hours if you work more than 40 hours. And as long as you are not in an averaging agreement, you are also entitled to overtime. Now, what we're discussing here is just for general knowledge. This will not be in your exam, okay? So overtime we discussed, 1.5. The excessive hours after 8, and 2 times the excessive hours over 12 hours. Vacation, there are 2 things about vacation. First of all, vacation pay minimum is 4%. If you work up to 5 years, more than 5 years, 6%. Now you can get paid on your every pay stub, or 1 week prior you go on vacation. It's at the discretion of the employer. Now, this is vacation pay, and you are entitled to vacation pay after day 5 you started working, even if you were in probation. Now, vacation time, you are entitled to minimum 2 weeks. If you have worked up to 5 years, more than 5 years, it goes up to 3 weeks minimum. This is vacation time. You are only entitled to go on vacation after 1 year of service. Okay? Then you don't get paid during those 2 weeks, but the vacation pay you got every pay stub should make up for that time. Holiday. I mentioned about holiday here because there are some holidays in Canada there that are only federal, and there are others that are only provincial. So there are 2 holidays that are only provincial in BC. What are those holidays? 2 provincial holidays. Does anyone know? And guesses are okay. Canada Day? No, Canada Day is a federal holiday. It's both federal and provincial. Yes, BC Day is one. That's right. BC Day is only provincial holiday. It's only holiday in BC. So BC Day, which is in August, you will see that post office employees will be working because they are federally regulated. You will notice that banks will be open, etc. So that's one. The other one, Victoria Day. No, Victoria Day is both federal and provincial because Victoria Day is related to Queen Victoria, not the capital here of BC. It's another one. It's in February. The other provincial BC day, provincial BC holiday. Family Day, that's right. Family Day is only provincial too, not federal. Okay, so in those days, people who are provincial, or employees and employers who are provincially regulated, they are on holiday. The federally regulated ones are not on holiday. And there's only one holiday that is federal only, not provincial. It is in December. No, Labor Day is both federal and provincial. I think it's the first Monday of September. It's in December. What is a holiday in December that is only federal, not provincial? Anyone? No, not Christmas. Christmas is both federal and provincial. It's after Christmas, but it's before New Year's Day. Yes, Boxing Day, that's right. Boxing Day is only federal holiday. Some provincially regulated employers, they allow employees to have a day off, or they make it optional, but it's not a provincial holiday. Okay? Now, is paid sick leave a right? Yes, it is. It is since January 1st, 2022. So after COVID, the provincial government changed the Employment Standards Act, and they added 5 paid sick days as a right. Those 5 days cannot be carried over. It's better if we don't use because we're not sick. But we are entitled to at least 5 paid sick days. And if companies offer more, it's fine. Remember, companies, employers, they can offer more, but not less. Not fewer days than the 5. Okay? Boxing Day statutory holiday? Yes, it's a statutory federal holiday, not provincial. So only for federally regulated employees. All right, so this is usually of interest to students or to employees in general, or even students who are business people. So that's why I bring this for discussion. But again, this is not applicable for exam. You will not have questions on the amount of minimum wage or anything else. All right, so moving on here, I will not stop for a break now because I don't need much more time to finish the lecture. Then I'll let you go if you're okay with it. So as I said, the Employment Standards Act deals with the minimum standards or protections, but employers can offer more. If it's offered less than the minimum, it's invalid. It's not that the contract is invalid. No, just that part. So if I am hired and I will be paid only $15 per hour, my wage provision is invalid, but the contract is still valid because I cannot be paid less than the minimum wage, for example. Yeah, and also those protections cannot be waived. I cannot waive my right to be paid the minimum wage, minimally. I cannot waive my right to have at least 2 weeks vacation per year, etc. We can't waive our protections. Now, if any of these are not complied with, we don't sue. We file a complaint with the Employment Standards Branch. So this is different from many other countries, like in Brazil, my home country. This is different. In Brazil, we sue for everything, for all employment related issues, but not in Canada. In Canada, we only sue for wrongful dismissal or constructive dismissal, or if there were any other torts or other civil matters, but not employment matters. Employment rights, they are solved in Canada by complaint. You make a complaint to the Employment Standards Branch. Okay. Well, we talked about termination before. Now let's talk about some legislation, some other legislation that is also applicable for employment relationships. One is in human rights. Actually, 60, almost 70% of human rights complaints in BC, they are related to employment situations. So be aware and know that while working, there may be issues of human rights that you should be careful about. Respecting employees, colleagues, also being respected by others, etc. So human rights prevents discrimination, and not only in the employment relationship, but also during hiring process. So if during the hiring process, if you are let go, disclassified because of any of the protected grounds, such as, are they here? No, they're not here. But such as, again, as I mentioned before, color, gender, disability, family status, religion, etc. If you are disclassified, well, even in hiring, you may have grounds to file a complaint. You should also remember that human rights issues, they are not dealt with by courts either. They are dealt with by the Human Rights Tribunal in BC. So this you know from chapter 2 and chapter 3. We discussed that human rights complaints, they go to the human rights tribunals. And the tribunal, the decision maker, they can order compensation, they can order investigation, they can apply fines. So they have a variety of remedies available to them. Now, employers, they can discriminate if discrimination is needed for the job duties. For example, I'm going to give you here a weird example, but discriminating a person who is blind for a driver's position. I know it's an absurd, it's weird, but just to help you memorize. So there's a genuine, there's a bona fide, as they call, a bona fide occupational requirement. You need to be able to see so that you can drive. So if the discrimination is related to the occupational requirement, to the job duty, then it's okay. It's not a violation. But still, it's on the burden of proof of the employer. If anyone files a human rights complaint based on that discrimination, the employer will have the burden to prove that their discrimination is a bona fide one, a genuine one. And it's related not to the individual, but it's related to the job duties, to the occupational requirement. So if you were to have a job description, for example, that says that the applicant needs to be strong, this is discrimination. Well, the employer meant that the employee, the successful employee, will need to carry heavy boxes, for example. So in the job description, they should have written heavy lifting or lifting of heavy boxes required. That's it. Because there may be some people who are not that strong, but they are able to perform those job duties. So employers, they should focus on the job duties, on the occupational requirement, not on the personal characteristic. Okay? But again, if needed be, they can discriminate as long as they have this bona fide, genuine occupational requirement. Some other issues here on human rights. Now, health and safety. Health and safety is related to prevention. That's why I mentioned to you in the very beginning that it's a right of the employee to be working on a safe environment, because the objective of legislation, of law, is to prevent an injury, to prevent a work-related disease. But sometimes that injury, that disease happens without negligence or even with negligence of the employer. So in those situations, there's workers' compensation. Workers' compensation is similar to an insurance. It's administered by the province here, the BC province, the provincial government. And the employers will pay a premium. The employee doesn't pay anything. And in case an employee is injured or develops an illness that is work-related, then they can file for workers' compensation. And workers' compensation will pay their salary, their wage, while that limitation, that injury, or that disease is present. There's also money for rehabilitation. I've had a student last or 2 summers ago, I think, taking this bill law course. They were construction worker, and because they suffered an injury, they came to study with workers' compensation money. So once you are injured, you file a complaint. Sorry, not a complaint. You file a workers' compensation claim. That claim will be either granted or denied. One thing here is only the employer pays the premium, not the employee. So if you work, or when you work, you will see that in your pay stub, there can't be any deduction for workers' compensation. There is for CPP, there is for taxes, federal, provincial, there is for employment insurance, but not for workers' compensation. Now, employment insurance, former employees will be entitled to employment insurance when they are dismissed without cause for some time. And also, current employees may be entitled to employment insurance if they leave because of an illness, they are in a treatment, or they leave the company because they are in disability, temporary disability, or if a woman gets pregnant, or if parents they adopt a child. So all those statutory leaves, if you are entitled to go on such a statutory leave, you may be entitled to employment insurance. There's specific time length for each of those leaves, but all you need to understand is that you may be entitled to any of those leaves, and you would be entitled to employment insurance too. Now, both the employee and the employer contribute to employment insurance. If you resign, if you leave the company on your own, you resigned, then you are not entitled to employment insurance. Nor will you be entitled if you are self-employed. If you are self-employed, independent contractor, you are not entitled to employment insurance. Question for you. Okay, I see one answer, C. Anyone else? A or B or C? So all the situations here, to avoid a complaint of gender discrimination, so this is specific to gender, either man, woman, transgender, and all the genders that exist. So employer should do all of the following except, well, should an employer permit an employee to breastfeed in the workplace? For sure. If they don't, it's going to be discrimination against women. So A is not right. A is not the right answer. Should an employer refrain from asking women in job interviews whether they are pregnant or plan to have children? Yes, they should. They should refrain from asking those questions. Because if they do so, they may get an answer that may lead them to disclassify. So no, not B. Should they ensure there are an equal number of female and male employees employed by the business? No. So your first choice, Tyree, was right. C is the false statement here. There's no requirement, not in the provincially regulated employers, to ensure that there's the same number of men and women and other genders working at a company. No. So C is the right answer. Now D, should an employer accommodate a pregnant woman with respect to her pregnancy? Yes, if she needs. Yeah, for sure. Should an employer reward men and women equally when doing equivalent jobs? For sure, definitely. Yeah. So an employer should do all this, A, B, D, and E, but not C. C is not a requirement. So Diego is saying, in regards to A, how can an employee allow someone to bring a newborn to the workplace? It doesn't seem right. Well, it's not allowing the newborn to be in the workplace, but to allow an employee to breastfeed. So it could be that the partner would bring the newborn to work just for the newborn to be breastfed. I see your point, but it's a way to accommodate the need to breastfeed with the job requirements. So the employee would be working, but if they are still breastfeeding their newborn, or because there are children that are now 1 year old, even 2 years old, if I'm not mistaken, and they are still breastfed. So if that is the case, the partner could bring the child to the workplace just to be breastfed at a certain time, and then take the child out. Does it make sense? I know it. I know it may be weird, but that's how it is. I think this is why we got complicated in the exam. It's about interpretation. Without that additional context, I can't say that A is not the correct answer. Well, but let's not think about the additional context. Let's think about this, because you are assuming that the child would stay in the workplace for the entire day. So this is an assumption. So the question is saying that the employer should permit an employee to breastfeed, not to have their child at the workplace during the entire day, because the newborn could need to be breastfed. No. So that would be an assumption. If you don't overthink, if you think about what is stated there, so permit an employee to breastfeed in the workplace. That's what it is. So only the mom can breastfeed. So yes, they can, right? I'm not saying you're wrong. I'm just trying to explain and to help you understand and not assume or not add context here. All right. So that's it. As I mentioned before, I won't be discussing about collective bargaining.